Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the state of New York, may now draw near, give their attendance, and they will be heard. All please be seated.
Good afternoon, everyone. The first appeal on this afternoon's calendar is appeal number 67, Maddicks versus Big City Properties. Counsel?
Good afternoon, Your Honors. Simcha Schoenfeld of Kuss & Schoenfeld, and with the court's permission, I'd like to reserve 2 minutes for rebuttal.
2 minutes?
Yes.
Yes, sir.
Thank you. May it please the court, this action and the matter before the court today is essentially really a broader question of whether CPLR 3211 should be applicable in any context to a class action complaint. And it's the position essentially of the plaintiffs and certainly of their amicus that the motion to dismiss pursuant to 3211 should have been denied merely for being premature. As the dissent, Justice Friedman correctly stated on page 311 of the record, and he wrote as follows: "To be clear, the point I am making is not that the common questions will not predominate. It is that questions common to the class, predominant or otherwise, simply do not exist."
So counsel, if a plaintiff, former or current tenant, claims that the landowner has pursued a scheme to violate the law for purposes of profit and gives examples that apply to the plaintiff and the other plaintiffs who are named, what is missing from that? It strikes me your position is that one can never set out a class action based on an illegal scheme or a scheme to undermine the law.
No, respectfully, Judge Vera, that's not my position. In fact, there is case law allowing class actions to proceed in J51 cases.
Okay, so what's wrong? I know you've already conceded that. What's wrong in this case? What's wrong with this amended complaint?
Because this amended complaint alleges at least 4 unrelated, disconnected bases for liability. They include violation of J51, improper registration.
Yeah, but isn't that why the legislature has provided for subclasses?
Well,
what would be the point of a subclass if not to address the concern that you raise, that somehow some of the plaintiffs only represent these problems and not the other, when the overarching argument of the plaintiffs is that there is a scheme. The scheme plays itself out in different ways, but there is one particular scheme.
Because the one particular scheme would be akin to suing landlords for violating federal law without specifying what it is. Then you'd have to set up a class for...
Well, no, they specify what it is.
No, but the class
I'm asking you what's the deficiency in the specification?
The deficiency...
You're just complaining that they've specified different ways that this happens.
No, I'm complaining that by the nature of the way they specified it and the class that they define in the complaint, in the 4 corners of the complaint, which is what's subject to the 3211 motion, there is not a single common question that can apply to the class. It doesn't...
I'm sorry.
Well, what do you say is the harm in the trial court deciding the certification question after the defense have answered? You see what their defense is, which may play into whether or not there is a commonality or not, and then allowing for the process of a CPLR 902 motion to certify, which appears to be the way the legislature intended it to happen, in most cases at least, maybe not in every case. But certainly given the number of cases that we have where the 2 statutes intertwine, it would seem that it would be an unusual case. So what's the harm in allowing at least that initial process to play out?
Well, Judge Stein, I would argue that the harm, that same question could be asked about any pre-answer motion to dismiss. What's the harm in going through discovery, and let's see if there's a substantive case here. The purpose of 3211 is to dismiss at the pleading stage, a pleading that is on its face.
Well, let me slow you down for a second. Isn't it a fair reading of 902 that the legislature has said for class certification issues there's going to be a relatively short 60-day period for discovery? And wouldn't it be a fair reading of 3711 and 902 together, that 3711 allows you to make a motion to dismiss on any grounds if you'd like, except if what you're complaining about is a failure to meet one of the requirements for class certification, that isn't really going to get the claim dismissed because the individual claim will still exist. So that has to wait, the legislature said, for 60 days for the plaintiff to make a motion and the court to rule on it. Why isn't that a fair
Because, Judge Wilson, our position
reconciliation of the
here
statutes?
is not that they failed to satisfy the criteria. That's the appropriate standard of review on a motion for class certification. Our argument is here is that they failed to plead it in the first place. The pleading itself, the four corners of the complaint itself does not set forth.
That doesn't get you a dismissal, though, right?
I'm sorry.
That doesn't get you a dismissal because the individual claims are still pleaded properly.
The individual claims are actually proceeding right now in this action.
If you're going to focus on one element of the 5 class action, would you focus on commonality?
Absolutely, Your Honor,
Okay,
yes.
tell me why in commonality you would say that that's the weakest of the
Very
petitioner's
simple.
arguments.
We have, let's say, a class of claimants who are claiming violation of J51, a class of claimants who are claiming improper or inadequate IAIs. What is the same question that could be asked to both of them? There isn't
So
one.
before you go into the elements of them, tell me why they aren't subclasses of an overall fraud claim.
They haven't been pled that way. That's why.
Oh, so you're saying, I'm sorry, just so I understand what you're saying, if they pleaded just the IAI claim and nothing else, you would concede that that's a common issue?
No, I would not. I don't think we have to reach
Okay,
that
then
on
that goes
this.
back to Judge Fahey's question.
I don't think we have to reach that question on this appeal, but with respect to IAIs, each apartment is a separate and distinct analysis of whether IAIs
See,
were done.
that argument, I have trouble with that argument because I think then, once you move beyond the subclass question, then you're really talking about the measure of damages that would apply to the overall class, not to whether or not the specific elements are met. In other words, whatever it costs to put in drywall in 200 different apartments, those are measures of damages. That's not what we're talking about here. I think really we're talking about whether or not the subclass classification is relevant to the claim.
Well, Judge Fahey, respectfully, I would submit that it's actually not exactly the way you presented it, because with respect to IAIs, the first question you have to actually ask is, are you in the class? We need to do an analysis to determine who is in the class in the first place.
I saw the statute of limitations. Go ahead, Judge. Go ahead.
I want to look at record page 53, paragraph 213 of the complaint. All right, it's getting into the 4 corners of the complaint. What's insufficient about that to satisfy at least the standard as enunciated in Mall?
Because none of these alleged facts common to the class apply to the entire class. They apply some to some claimants, some to others. And with respect to the IAIs, I
But
would...
isn't that what Article 9 allows the trial judge to do, to say, okay, maybe these people don't all belong in one class, but I, the judge, can separate that out into subclasses? I think
That's
so.
if the pleading is sufficient to survive a 3211 motion in the first place.
Yeah, but so back to Judge Feinman's question, why isn't the pleading satisfactory here?
Because the pleading lists very specifically what the 2 classes are. They appear, the classes appear on page 51 of the record, paragraphs 200 and 202.
Are they current and former renters? Is that the
Yeah,
classes they
across
want?
the board.
Right.
And
And those
with-
are how they're pleaded in the counts, right? So
Correct.
there's, I think, 3 counts on behalf of the class and 3 counts, I think, on behalf of that specific subclass.
That's correct,
right?
and J51 is not even separately pleaded, and just with, I see my time's expired, just a few more seconds if I may. With
Amen.
respect to IAIs itself, the pleading itself is insufficient as a matter of law, class action or no class action, because what the complaint alleges repeatedly and consistently throughout the complaint, and the first time is paragraph 12 on page 30, is that an inspection of the apartment, and I quote, suggests that IAIs were not completed. If a mortgage lender were to foreclose and state in their complaint that the evidence suggests that
But
the
the law
borrower...
requires that you read the entire complaint. And there's other language in the complaint that cut completely against this argument, which is you're saying they're speculating whether or not indeed that...
I'm not saying they're...
Excuse me, that they're speculating as to whether or not there has indeed been a violation when it's very clear that is exactly what they're alleging.
Respectfully, Your Honor, I'm not saying they're speculating. I'm saying they're being very clear. They're clear is that there is a suggestion. There is no affirmative statement that IAIs were not properly done. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Roger Sacker, Newman Ferrara. We represent the respondents. May it please the
So is it your position that such a motion is always premature, as your adversary says your position is?
No, it's not always premature. First, you can always make a 3211 motion and just simply attack the representative plaintiff's claim. If they have no claim, they have no standing. Here, for example, they could have put forth proof of $81,000 in IAIs to demonstrate that Ms. Pirro had no claim. If they demonstrate that, you can't go forward. That's the first instance. Second instance is if you can't actually ever have a class action. And that applies, that's the Downing opinion. In Downing, the question before Judge Ramos at the trial court level was whether or not you could waive the treble damages penalty. And that case went all the way up here to Borden. Now, if it had in fact been the case that you were required to seek treble damages, you couldn't have a class action. That's okay to dismiss. The issue here is whether or not you can dismiss for failure to establish in a complaint the 901A prerequisites. And I would posit that you can't. First off, we were talking about commonality. Well, in a 906 class action, you don't even have to have commonality. 906-1, you don't need it. There's no requirement for commonality. What my adversary is trying to have us do is put the cart before the horse. And he's saying, Mr. Sacker, in your complaint, you have to decide how you are going to certify the class. And I don't think that's proper because you do class discovery that we talked about with the 60-day period. You do class discovery, you decide how you're going to certify the class. Here it may be a 901A class for the failure to register claims and a 906-1 issue class for the IAI claims.
So why, if you're doing that, it seems to me this is a subclass action then. In a class action, do you need one overarching predominant common law issue or common issue of fact?
In a 901A case, the subclasses themselves can have common issues. You do not, although we do have one here, the common scheme to evade the rent
So you could just put 4 different subclasses together, against one defendant, have nothing to do with each other, and get that certified? Because you have 4 subclasses that have predominant common issues of law or fact.
If you establish the other prerequisites for each subclass, yes. And remember,
what does that get you? I don't understand how that fits in with the purpose of class actions. That you're bringing this class action, I'm having a hard time seeing any issue common across these different categories. So what you're asking for, it seems, is a certification of 4 subcategories, 4 subclasses. Why would that be part of a class action proceeding against this one defendant? I don't understand that.
Well, because you're looking at superiority in that case. And a court can decide, if this is not superior, for these 4 claims are not superior, to be tried together. And at that point, at the certification stage, is when that should be measured, and the court should make that decision.
So
we're not there yet.
your view is you do not need an issue that's common across every class here. The J51s, the IAIs, the failure to register, they can all have completely separate and independent factual and legal issues. But can you do that? And then you could get certification here.
Conceivably, the answer is no. There are circumstances in which you wouldn't have commonality. And I'll give you an example. If you were suing Joe's Drive-In and Steve's Burger Shack, both for different cases of food poisoning, and you tried to certify them in one class, well, those cases, the two have
Let's say
nothing to
you're
do
just
with each
suing
other.
Joe's for food poisoning and some labor dispute.
Right.
You've got one defendant.
Arguably, you should split those claims.
Well, I thought your claim was that the overarching common issue is that these landlords were engaging in a scheme to overcharge tenants by violating the rent stabilization law, but that some of them did it in different ways.
Precisely, and that's why we have actually.
That's
Or did it
the way
multiple ways.
that's the way I understood it, also the way Judge Stein articulated it.
That was my question to your adversary. Was he challenging that one could ever argue for class action status based on a scheme that has multiple characteristics.
Right, and that's where we get the difference between Joe's driving with a labor dispute and food poisoning.
So just to tie this up, how would you articulate the common question of law and fact?
You have a common scheme by a real estate portfolio owned by the same holding company and run by the same management company to evade the rent regulation.
What is the legal or factual issue there? That's like saying you're not paying your workers enough. You're charging too much rent. What's the common legal or factual issue? In one case, the facts depend on whether improvements are weighted in the cost of those improvements. In another subclass, it's J51. There's no common legal issue there. So you're breaking the law? You're charging too much rent?
You're violating the rent stabilization law and rent stabilization code. That's the scheme. It stretches throughout this portfolio. It's different ways in the same way that Mall was different ways, in the same way that Weinberger v. Hertz was different ways. In one case, they're charging too much for a rental. In the other case, they're charging too much for gas. It's a common scheme of evading the rent regulations. That's the tie. That's our difference between Joe's driving labor dispute, Joe's driving food poisoning. That's your difference.
And your position, I take it, is that even if you're wrong about that, the court could certify 4 subclasses or 3, whatever number it decided on, one for the J51 issue, let's say, one for the IA issue, et cetera, or could choose to certify one but not another of those, and those classes might have different members, maybe none in common, and that would still be permissible under the rules.
Absolutely. If the court says, if we get to the stage where we are talking about III claims at the certification stage, and the court says, look, I've read Borden. Borden says I have to certify a J51 class. You've satisfied the criteria in Borden. I'm going to do that under 901. You don't have it, Mr. Sacker, on the III claims. I'm sorry, you can't do it under 901, can't do it under 906. Those claims need to proceed individually. Okay, well, that's what happens with those claims. The issue here is that the court made that determination before I'd even asked the court to do it. I hadn't got to put forth a pleading. We hadn't had the ability to tell the court, this is our plan based on discovery.
If I'm right, the appellate division dismissed 8 defendants from the suit?
No, right? So there's in the real estate portfolio, there's 16 different LLCs that are the single-purpose LLCs. At the trial court level, Justice Edwards dismissed 8 of the LLCs for who we had no plaintiffs, and we're not challenging that.
That's all I was going to ask, is you're not challenging that.
We're not challenging that. She then sua sponte did the remaining 8 plaintiffs. The only other thing that I would point out is in the Amici's briefing, I just want to quickly note that they talk about cases that are, the majority of cases allow you to analyze class cert at the motion to dismiss stage. The cases they're citing to are Fair Labor Standards Act cases, and in those cases, because they have a conditional certification requirement, also have an ascertainability question that has to be assessed at the initial stage. So those cases, and I think there's 6 of them in total, 2 are FLSA cases and a few more have to deal with ascertainability generally. That's a different question.
Just on a different topic, just briefly, exhaustion of administrative remedies, has that issue been abandoned?
No, it's dead. It's dead. Our legislature on June 14th, 2019 stated...
because of the change of the law, you're saying?
Change in the law. And in any event, you can't send to...
And you mean, just so we're clear for the record, that you could go to either court or go to DHC?
Yes, the legislature, the new rent laws say the court of competent jurisdiction or the agency subject to the tenant's choice of forum. So that claim, to the extent it ever was proper in a class action, is long gone now.
Thank you, counsel. Counsel?
I think the analogy that Mr. Sacker gave about, I don't remember if it was Bob's or Joe's or whatever, the 2 different shops, is actually quite relevant here. With respect to the J51, to use that as an example, those claims are made only with respect to 4 of the properties in the remaining, in this portfolio. There are 7 to which there's no allegation of J51 violation. If a class were to be certified, including them as a defendant, they would be defendants in a class action making allegations that have nothing to do with them. And in fact, for that matter, the 8 properties that were dismissed by the lower court and affirmed by the appellate division, and as Mr. Sacker said, not before this court, why shouldn't they be defendants too? If you can be defendant in a class action for a claim that is not made against you, then why not include everybody in the portfolio as well? And that-
But doesn't the court, if it, let's say it thought that certification for the J51, the conditions for certification had been met, why couldn't it certify a subclass of people in the 4 buildings and dismiss the other defendants as to whom there's no claim?
Again, Your Honor, that would be something to be considered on a motion for class certification. Whether the court has the authority to do that is a separate question. But here, in the context of a 3211 motion, we don't get to speculate what a trial court may do. The question is, within the 4 corners of this complaint, is a class action adequately pled? And just one final point, throughout their papers and during Mr. Sacker's argument today, the plaintiffs have continuously stated that it's our position that they failed to establish or to satisfy, et cetera. That's not. Our position has been from day one, this is a deficiency at the pleading stage. The pleadings are insufficient, not a lack of proof, not a lack of evidence, not a lack of proof of defense, none of that. It's that the complaint on its face fails to state a claim both for class action relief and with respect to IAIs, even for individual relief. Thank you very much.
Thank you, counsel.